All right. Welcome back to Billen and Belhomme, where we dive into the world of wealth, law, and sometimes the great missteps of legal legends. And today's topic is Warren Burger, a former Chief Justice of the United States and a highly respected legal mind. But when it comes to his estate plan, he chose a surprising route, the DIY will.
Yeah, brilliant, Maxime. I didn't know which topic you were going to pick this week, so I was really pleased to see we're going to do Warren Burger. It's a real funny one, isn't it? Because as you said, this guy wasn't just on the Supreme Council of the United States; he was the Chief Justice. So arguably the top lawyer in the whole of the United States at the time, and he absolutely screwed his will up. So, yeah, this wasn't just any guy doing it for himself. We're talking about a legal heavyweight.
Exactly.
And even though he had some elements of an estate plan, when Berger wrote his will, it was a mere 176 words. So it was more like a tweet than a comprehensive estate document.
100%. And I mean, while it wasn't just a complete disaster, he like his will really left a lot to be desired. So the DIY approach, which I think it's very curious, even for someone as accomplished as him, still missed some critical elements and aspects. So sure, he and his wife had some estate planning strategies in place, like trust and lifetime gifts, but they weren't ignoring tax issue altogether. But a more thorough plan would have made like a whole lot of difference.
Yeah, that's right, Maxime. So yeah, they used up some of the wife's tax exemption, deferring a bit of the tax burden, but his estate still ended up paying about $450,000 in taxes. So it's close to a quarter of the total estate value. More could have been saved with a bit more professional input. It's a bit like doing some of the legwork, but skipping the final touches. That would have really made this a great plan. So yeah, devastating result from not doing this properly.
100%. And the final touches in the estate planning matter by kind of DIYing his will. Berger skipped over important provisions like giving his executor, in this case his son Wade, and his associate J. Michael Lutig, enough authority to actually manage the estate. So of course they could distribute it, but they weren't granted the necessary power to handle key responsibilities like selling the property or paying tax directly.
Yeah, exactly. So this lack of detail made the probate process more complicated than it needed to be. A good estate plan gives the executors of the will, so these are the people that are responsible for putting together an inventory of what your assets are, what your debts are, clearing that, and then paying things out properly to the heirs that are named in the will. A good plan should give them a really clear roadmap and the ability to handle assets with without needing additional permissions. This is very important more these days with things like digital assets and where people have perhaps like a big YouTube account. If you've got a lot of followers and you die and nobody can get access to it and things like that. A lot of the tech platforms do have a lot of rules and delegations around that. But putting it in a roadmap that sits alongside the will would have been a good idea. So yeah, so that's the difference between a nice streamlined process that's well organized and one that like this one got bogged down in the courts or hit with a horrible tax bill.
Uh, Completely agree. I mean, imagine being his son, like in Wade's shoes, named the executor of kind of a $1.8 million estate, but his hands were practically, tied because the Chief Justice will, like his father, didn't include any practical instructions.
Yeah, exactly. Another way of putting it, it's a bit like being asked to manage a business, but you've got no real authority to do so, right? It's a very frustrating position. You've got a lot of responsibility on your shoulders, and you can't undertake them because the documents weren't done properly. So yeah, it's a big reason why probate costs for Berger's estate ended up being much higher than necessary.
Exactly. And so let's get into the probate process a little bit more because this is where actually the DIY approach really, backfired, I would say. Without clear provisions, executor might have to file extra paperwork, face probate delays, or need some court approvals for just routine actions, all of which means more time, more stress, and ultimately a lot more money spent.
Yeah, I mean, probably like here, like doing a plan and then regularly updating it as you go along, it sort of automatically becomes a holistic plan. So it's not just something that you said it once and forget it. It's like a lifetime living document. And so even though Berger had done some planning, he didn't adjust for any changing tax laws or financial growth. Obviously, estate laws shift, family circumstances change. So, your documents and your plan needs to sort of be flexible and something that you're always managing as circumstances change. And as we say, there might be tax change, or your wealth might go up. And if you haven't updated your estate plan, you could get caught out very badly. I mean, obviously, a lot of changes happening now. We've had a big budget change in the UK. We have the US elections next week. We're recording this on Halloween in October 2024, hence why we're a little bit more dressed down today. But yeah, Berger should have been a bit more aware of what was going on. And as we say, we sort of chuckle a bit at this case because he was the most senior judge in the whole of the US, and even he still got it wrong.
Exactly, the MVP, but ended up writing just 176 words that ended up not being as he would have wanted. So, like you said, a lot of things can change. So, a good estate plan does actually way more than just say who gets what. It's also about ensuring that, whoever handles your estate has the right tools and that your family just isn't left trying to interpret some vague language.
Yeah, good point. I mean, that's a really big point, isn't it? And we see that with trusts as well, that being as specific as you can and as clear as you can is much better. The more assumptions or things that you leave open for other people to decide, the more likely a court might have to get involved, which is going to cost a lot of fees out of the trust fund or out of the estate. The more likely that people are going to be arguing. So it's something that you start early, and you work on it every month or something. You sit down and work on it, and you just keep working on it, and you grind it out. It's a bit like bookkeeping in a way. People that have got businesses, the last things they want to do is do their bookkeeping and they prepare their financials, right? But once you sort of get into it, it's something that you're proud of. And I think exactly the same with an estate plan, right? It's something that you don't want to do, you don't want to think about, but once you get into it, you can go really deep. You can make it a brilliant plan, and you'll feel proud of it, and you will relieve an enormous amount of stress, both emotionally, time-wise, and financially from your heirs.
Exactly. And I think like you said in the legal world it's very important to be very specific. I think that the fewer assumptions we have and it just makes things easier for the executor, but ultimately burgers will, left a lot for interpretation, which ultimately increase costs and as well potential conflicts. So this is really where the expert input should come in, and professionals can help make sure that your will is not only clear but structured to maximize what's left to your heirs and avoiding any unnecessary delays or taxes.
Yeah. I think didn't you have a case, Maxime? I think you mentioned one about something about somebody who forgot to specify something about the assets in their will.
Yeah, yeah. I mean, I don't remember the name of the case. That is something that I heard about. Someone wrote their own will and actually forgot to specify who was supposed to be the executor. So who could actually make the decision on the certain assets. So the family ended up in court for nearly 2 years just to get, clarification and over like a basic, oversight in wording can create a huge headache for heirs. And I think you're mentioning this morning as well that in Switzerland, like your will has to be handwritten. So just adding more complexity to the whole will and understanding what's actually written.
Will has to be handwritten, exactly. So even like a type will not be valid. Yeah. So well, it has to be handwritten, or you have to do it orally in front of a notary who will then handwrite it. But yeah, exactly. And do you think what do you think's worse? Not appointing an executor, or doing Robert Palmer and appointing your alcoholic, drug-riddled band manager? What do you think's worse?
That's a tough one. I would go that the Robert Palmer it's maybe worse because I mean ultimately, let's say you don't appoint anyone, the court will take the decision to appoint someone, so it might cost you more time, but I mean, your alcoholic buddy is clearly not the expert you want handling your will.
Yeah, probably easier to get a court direction to have somebody appointed rather than trying to get somebody removed or changed, right? So yeah, I agree on that. So yeah, another classic story. And yeah, I heard of a well, we've seen this a lot in trust law, you know, where you have things that say, "Oh, divide everything fairly." So, you know, you might want to sit down and do it once. Oh, you know, you take care of that when I die. Just divide everything fairly between everybody. Like, okay, what's fairly? What's
Yeah.
everybody?
And I
So,
mean,
yeah.
it all depends when you take the decision, you know. I think it goes back to Berger making his will maybe too early and not updating it. Okay, it's fair to split it in two if you have two children, sorry. But what happens next, you know? You really have to think about making the instructions clear, and ultimately it just makes it way easier for everyone involved. I mean, we can go back to the Jimi Hendrix case, you know, where no will. Well, so what's better now, in your opinion, Ross? A poor DIY will or no will?
Oh, I think a DIY would at the end of the day, right? At least you've left some wishes, right? Some idea about what you wanted,
Hmm.
and the hope that, like with the Jimi Hendrix example, let's say he done a post-it note saying, you know, I want my brother to get X. It might well have been that whoever became ultimately executor might have respected that in some way, and there might have been a legal way they could have made that happen, right? I mean, normally with legal problems, is that they can always wait another day sometimes, and there's always some way that they can be fixed. You know, law is and more of an art than a science, right? So is normally it might be a piece of paperwork here or sort of something here and there that things can be worked out, right? So yeah, letting I mean even just orally letting people know what you would like to do, right, is probably better than absolutely nothing. I mean, absolutely nothing is probably the worst case scenario.
Yeah. I mean,
Yeah.
and it's not something that usually occur, let's be honest. Like you always like say mention at some point something, especially when you reach those, astronomical level of wealth and we mention it often on the podcast, like setting up your estate planning is not anyway a decision that you just take one morning. It's really something that takes, time, effort, and it's a ultimately it's a lifelong process.
Yeah. Yeah. And if you don't want to take it seriously, you know, talk to people that have had to pick up estates with no planning
Hmm.
and see what it does to your family,
Exactly.
and that will make you sit down and do that because it's almost this isn't about you, right? It's about not leaving a mess for your family, your wife and children, whoever, and you can leave them years of distress, and they'll be cursing your name, or because you just couldn't be bothered to take an hour every other Sunday
Hmm.
to sit down and plan stuff, right? And I think with great wealth comes great responsibility, right? And because wealth does bring problems, you know, and you need to be organized and sort of professional person if you've got a lot of wealth, because it does cause problems, and it does ruin lives, and nothing destroys children like money, but nothing can tear a family apart than a lousy estate plan.
Yeah, that's for sure. And I mean, it's not, it is, I think this is not just for the wealthy. These lessons really apply whether you have a whole lot of money or just a little on to pass. And anyone with a family or assets, should really have a will that's detailed, legally sound. So if in Switzerland, make sure it's handwritten and up to date. That's really
Yeah.
the
Yeah, so yeah, we could recap with some takeaways, couldn't we? So it was a straightforward case, this one, but yeah, first give the executors of the will the power they need to handle any assets, so particularly if you've got unusual assets, and don't assume that they'll be able to act without that authority.
100%. So don't make just a 176 word will. And second, I think, don't overlook tax planning. Even small adjustments can lead to major savings. And in Berger stories, it really showed, basic tax conscious choices can only go so far without a fully formed strategy.
Yep, and maybe a third thing is to sort of, as we've said, be very clear and specific as you can. Avoid vague language. Don't skip over asset details. You have to sit down and really think about, okay, what bank accounts do I have? Where's this? Where's that? You're just going to leave confusion and pain for your heirs and the executor.
Exactly. And I mean, to sum it up, we've mentioned it millions of times today. Just keep it updated, you know. Make sure that whatever is happening, would it be in your own situation or in the law, make sure that it's not a one and done type of document. And as law family evolves, your estate plan should also.
Yeah, yeah. And
So,
just one thought. What do you think about people should just spend all their money before
I
they
mean,
die?
I see it more and more, uh, because ultimately, why work so hard if you don't enjoy it? So do you want to just spend it all in your lifetime, or is it more a vision where whatever you made, I think you mentioned it last time, you are just, the holder for the family, you know? So it all depends. If you made it yourself, maybe you're allowed to spend it. But if it was passed upon you, it is not, I don't think it's your right to spend it then, you know?
Right. Yeah, actually, that's a nice way to look at it. If you've inherited sort of multi-generational wealth rather than something that you've earned with your own sort of skin and bone. Yeah.
Hmm.
Hmm.
So this is where I would put the difference. Like, I would always argue that, it's good to prepare for the future, to prepare for your children, to prepare for, especially if you want to, make an impact. If you want to make an impact, you don't want to just do it in your lifetime. You want this impact to be, long lasting. And this is where, having really the chance of doing a 300 years kind of project, this is where having your wealth continuing is important. But then you can always, I think it's, don't forget to have fun ultimately, right? Life is short, so make sure that you don't just plan always and are scared of the future, but really enjoy the moment and be mindful for the future.
Yeah, that's what I see. I do see some clients who, even in where all their heirs are independently financially fine, they're still clinging to the capital and they only want to touch the income on their pot and things like that. But then, um, I can understand, right? Obviously, people want to make sure that their heirs are financially looked after. There's that part, but also I think just because they have worked and grinded away so hard to build that pot, they do want it to sort of pass on. But yeah, there's an element you could say from here. I mean, this is a pot where look how hard this guy worked, and just because he didn't do one document at the end properly, the whole thing fell apart. Yeah,
Hmm.
so that's the little bit of paperwork can really just make your vision happen or not. But I think there's definitely a role for blowing a bit of the family fortune and or gifting it during your lifetime as well, and which can be tax advantage to do that as well. Perhaps some people cling on to the money. They worry whether they're going to have enough money in old age, that sort of thing. And they don't. I've seen cases where you've still got children in their 60s and they haven't inherited any money yet. The parents are in their 80s and they're in their
Hmm.
60s. And you're like, wow, perhaps you should have passed the money on at that point. But yeah, difficult. It depends on the family dynamics and that. So
100%. I think, yeah, you summed it up well. It's something very personal ultimately. It's about your family, whatever you want to decide. But just one tip, don't DIY your estate plan. I
yeah,
think this is what we really want to emphasize today. Make sure to leave it to the pros and, give your family the peace of mind they deserve.
yeah, cool. Well, thanks for joining us. Thanks, Maxime. So yeah, do all of those things and make sure your will is longer than 176 words
Easy and handwritten in Switzerland.
and handwritten in Switzerland. Yeah, absolutely.
All right. Thanks, everyone. See you soon. Bye bye.